Welcome back to What Do I Know? Why did CEC's investigations fail? This video is going to explore ground number 10. So for you to understand what ground number 10 is, I'll kick on. Ground 10, use of evidence acquired illegally. Breach of the rules of evidence, 5 counts. So there's 5 breaches of the rules of evidence here. Evidence that is either obtained through improper means or is acquired illegally is not admissible in investigations. Where a party to an investigation notes that there is evidence present which has been improperly obtained or acquired illegally, that party must immediately notify the investigator of this discovery and show that this evidence is tainted. The correct procedure to be taken by the investigator is then to cease the main investigation and to then absolutely consider the allegation that the evidence is as claimed, that it has been improperly obtained or acquired illegally. If it is found that the claim about the evidence is true, then the investigator has to notify his or her instructing client about this discovery. The investigator must then disqualify the evidence, particularly if its inclusion would make the investigation and its process unfair on one or more parties. The investigator must also notify all parties to the investigation of the decision to disqualify the evidence and give reasoning therewith. The evidence must be recorded as being inadmissible in the investigation evidence logbook, the main logbook and the investigator's notebook. After doing this, the investigator must consider whether or not to report the issue to other authorities, for example, the police. Again, here there has to be human rights considerations. Both Articles 6 and 8 are active here. At this point, the provisions of Article 6 must be recalled. Article 6, Human Rights Act 1998 states, you have the right to a fair and public trial or hearing if you are charged with a criminal offence and have to go to court, or a public authority is making a decision that has an impact upon your civil rights or obligations. At this juncture, it is critical to note that both points here are upon an or basis. You do not need to show both. Article 6 is both applicable and operable in this case, as CEC is a public authority sought to make decisions which would impact on the civil rights and obligations of BT, BB and AB. Civil rights in this case are rights and freedoms given to residents and citizens of this country through our country's legal system. These include freedom of speech and freedom of assembly. Those rights are legally protected, which means that everyone has the right to live a safe life free from harassment and hatred. Consideration must be given to what rights BT, BB and AB actually had and were entitled to, as there is one that is applicable in relation to evidence and the right to use it. BB, AB and BT had the right to 1. Be presumed innocent until they were proven guilty. B. To be told as early as possible what they were accused of. 3. Remain silent. 4. Have enough time to prepare their responses and or case. 5. Access to all relevant information. 6. Put forward their side of the matter and their case. And 7. Either question the main parties against them or to call other witnesses or insert other evidence supporting their case. Article 8 must also be considered. Article 8 Human Rights Act 1998 states, 1. Everyone has the right to respect for his private and family life, his home and his correspondence. 2. There shall be no interference by public authority with the exercise of this right except such as in accordance with the law and is necessary in a democratic society in the interests of national security, public safety or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. There are restrictions on this right. There are situations when public authorities can interfere with your right to respect for private and family life, home and correspondence. This is only allowed where the authority can show that its action is lawful, necessary and proportionate in order to protect national security, protect public safety, protect the economy, protect health or morals, prevent disorder or crime, or protect the rights and freedoms of other people. Action is proportionate when it is appropriate and no more than necessary to address the problem concerned. The assessment found that none of these restrictions applied to the investigation in question, as it would have been wholly disproportionate to apply them as such. It is also of critical importance that where evidence is acquired for an investigation and it is found to be admissible, that the investigation ceases and a separate investigation into the source of the evidence is undertaken. If it cannot be satisfied that the evidence is bona fide, that means is Latin basically for actual, for true, proper, and has been acquired legally, then it must be dismissed. A full record and report made containing the reasons why it has been dismissed, and the entity responsible for it reported to the appropriate authority as is necessary or required. A conclusion has to be drawn as to whether or not it would be principled to continue with the investigation should evidence that has been tainted come to light and such behaviour causing that. Before the focus turns to noting the 5 counts and how the illegality was committed in order to gain the evidence, attention must be given to the role of data protection in investigations. Any and all investigations must always comply with data protection regulations and obligations. Conducting an investigation requires the processing of personal data, that is, data from which a living individual can be identified. In the United Kingdom, the Data Protection Act 2018 and the General Data Protection Regulation, GDPR, govern how investigations may collect and use personal data. Among other things, GDPR sets out 6 data protection principles with which investigators collecting and using personal data must comply. An investigator must 1. Tell individuals how their personal data will be used. 3. Ensure that a legal condition for processing is met, for instance, consent of the relevant individual or compliance with a legal obligation other than a contractual obligation. Take appropriate steps to secure personal data. And 4. Not transfer personal data outside the European Economic Area, EEA, without ensuring an adequate level of protection for it. In addition, the Regulation of Investigatory Powers Act 2000, that's REPA, and the Investigatory Powers Act 2016, IPA, prohibit the monitoring of communications, whether by post, telephone, or internet usage. You must always assess when receiving personal data that it has been acquired legally. You have a duty of care to ensure that you check to see if the personal data was acquired lawfully. There are certain steps that should be taken in investigations with regard to data protection. One such step is before any information about an individual is collected, used or disclosed in an investigation, an analysis should be carried out to check that the collection, use or disclosure is lawful. What were the 5 established counts of use of evidence illegally acquired? They were as follows. 1. Submission as evidence in a formal complaint to the front page of the private legal advice belonging to BT, AB and BB by Councillor Cynthia Sampson. 2. The illegal video recording of the HPC Planning and Environment Committee meeting of the 10th of December 2020. 3. The illegal video recording of the HPC Full Council meeting of the 10th of December 2020. 4. Copies of private emails between BT, AB and BB sent to private email addresses regarding Avonshaw. 5. Copies of a further set of emails between BT, AB and BB sent to private email addresses regarding Avonshaw. So it's 2 different sets of emails. That's not repeated, 2 different sets. These 5 points will be expanded upon and further explained below. We now get to the victim impact statement entitled Who was affected and how. There were 3 persons, of course I was the one who was entitled to draft this being sole survivor. The 3 persons affected by this failure, and they were 1. The late Councillor Tolver, 2. The late Councillor Birkle, and 3. Former Councillor Brewerton. How were we affected? In order to achieve full comprehension of the effects on each of us of the above 5 issues, each will be addressed separately. Issue 1. Of viewing the appendices to the report into the complaints made by BT, AB and BT by Councillor Sampson, Moore and John Smith, it was noted that Councillor Sampson had produced in evidence a copy of the front page of a legal advice document belonging to us. The legal advice was that privately obtained from counsel regarding the clerk's illegal disqualification of a counsellor. Examination of this document also revealed something of a very concerning nature. The document had clearly been altered. Counsel's name had been redacted on page 1. We are in possession of the original document. Counsel's name does not appear on page 1 of that document. Never did. BT did supply a copy of the first page of the legal advice to the previous MO, but it did not bear counsel's name, nor the name of the chambers. One thing is certain here. We did not at any time share this with Councillor Sampson. We in fact decided not to share it with Councillor Sampson, Moore and John Smith, and certainly not the clerk. Our reasoning for this was quite clear. We felt that if we did share it with any of the councillors, that the confidentiality of this document would be maligned and surrendered because it would have been passed to the clerk. Bearing in mind there's a legal issue here and the clerk was the other side. Yeah? Counsel advised us that this should not be done as there was a real terms threat of there being a legal case between HPC and the clerk, and this could be used against us in a mendacious and vengeful manner. Finding out that Councillor Sampson had a copy of this document had a profound effect on us. We knew that our confidentiality, which we were entitled to have, had been completely destroyed. We were extremely distressed as we felt that the other 3 councillors and the clerk could use it against us in terms of having us investigated for misconduct in public office, which was a crime we simply did not commit. We were concerned that we could have been arrested on suspicion of misconduct in public office and remanded in custody for the duration of the investigation. The distress this caused was profound. We also held concerns that it might have been publicly shared and that our safety and that of our families and friends had been jeopardised. We also held concerns that our homes and property would be attacked. We had severe worries that our good reputations would have been significantly damaged. Issue 2. This concerns the illegal video recording of the HPC Planning and Environment Committee meeting of the 10th of December 2020. Any evidence which has been obtained by deception or has come about as a direct result of breach of law or by breach of human rights is also legally inadmissible and must be excluded from investigation. We've taken this advice from Council regarding the cut and splice video of the 10th December 2020, and it has been concluded that the recording of the meeting, which provably was not a public meeting, was done in breach of Article 13 GDPR, in that none of the attendees were informed that the meeting was being recorded and would be published. This is also a breach of Article 5.1 and 5.2 GDPR in that the personal data therein was not handled transparently, and therefore is a prima facie data protection breach. Anyone coming into possession of said personal data has a duty of care to ascertain that it has been legally acquired. The ICO has delivered a judgment in this instance, and they have confirmed that the action of the recording of the said video, the planning to do that, and its dissemination was an illegal and unlawful misuse of personal data. They confirmed that the advice from Council was legally correct, and advised that the video containing personal data should not have been processed as evidence. This video has been both manipulated and mutilated. It was not a true and accurate recording. In other words, the personal data contained thereon had been gravely mishandled in order to defame us. We ended having to defend ourselves, our families and friends against unwarranted attacks because of this video. AB was also attacked professionally and forced to defend his excellent professional reputation. I defended it, it survived, I survived. Issue 3. When I get to the end of this particular issue, I'm going to tell you something about how these videos came into the possession of Cheshire East. Wait for that. End of issue 3, and here comes issue 3. This concerns the illegal video recording of the HPC full council meeting of the 10th December 2020. Any evidence which has been obtained by deception or has come about as a direct result of a breach of law or a breach of human rights is also legally inadmissible and must be excluded. Again, we took advice from Council regarding the cut and splice video of 10th December 2020, and it has been concluded that the recording of the meeting, which was provably not a public meeting, was done in breach of Article 13 GDPR, in that none of the attendees were informed that the meeting was being recorded and would be published. This is also a breach of Article 5.1 and 5.2 GDPR, and that the personal data therein was not handled transparently, and therefore is a prima facie data protection breach. Anyone coming into possession of said personal data has a duty of care to ascertain that it has been legally acquired. The ICO has delivered a preliminary judgment in this instance, and they have confirmed that the action of recording the said video, the planning to do that, and its dissemination was an illegal and unlawful misuse of personal data. They confirmed that the advice from counsel was legally correct and advised that the video containing personal data should not have been processed as evidence. The video had been both manipulated and mutilated. It was not a true and accurate recording. In other words, the personal data contained thereon had been gravely mishandled in order to defame us. We ended having to defend ourselves, our families, and our friends against unwarranted attacks because of this video. AB was also attacked professionally and forced to defend his excellent professional reputation. We all three received death threats and threats to harm our families and friends. Right. Just before I deal with issues 4 and 5, which are dealt with together, I'm going to tell you how those two videos came into the possession of CEC, moreover, the then monitoring officer, Mr. Brown. I did an FOI request. I wanted to see the full whack of emails about the investigation and what's going on, the ins and outs, wherefores, and all that. I found in amongst the bundle an email sent by Ashley, the clerk, the weasel, dated, if I remember rightly, the 28th of January. And in that email was a link, and it was a YouTube link to the purported video of one of these meetings. We found that that link took us to the YouTube profile of one Janet Quinn. That's also Janet Taylor. You know what I mean? She can't use the same name. It's just to keep using different names. That's deception. That's deceit. That is actually an act of fraud. Just thought I'd let you know. But that's where they got it from. It was cut and spliced, and he was quite happy to give that. Now, what should have happened with that is realising, because we brought up saying that's not true and accurate video, just he shouldn't have used that, neither should the investigator. What should happen there is you should have sat down and smoked with us and said, right, hang on a minute, disclose where you got it from, because you've got to do that by law. Yeah, because at the time, people had written informed complaints, but you know what? They were just scribbles, from what I understand. There was no evidence. Until that email went in with that video, there was no evidence. There was nothing. Just people saying, oh, this happened, with no evidence. Until the clerk decided he was going to stick his oar in. And remember this, on the 28th of January, he was still technically suspended and had been illegally reinstated for the second time by Sampson, Smith and Moore. All right? There you go. I'm now going to deal with issues 4 and 5. Issues 4 and 5. These can be dealt with together and concern the copies of emails sent between BT, AB and BB sent to private email addresses regarding Avonshaw and the minutes of previous council meetings. These emails were sent between BT, AB and BB and from their own private email addresses. When we listened to the gentleman make the statement that was made in the public forum, as mentioned in ground 6, remember that one? Yeah. We automatically realised that emails that we rightfully believe were private, so only the three of us, had somehow fallen into the hands of the other three councillors. To make matters worse, Councillor John Smith read out large extracts and sections of these emails in HTC full council meetings. Several members of the public who were present contacted us and told us. We were able to secure a copy of the full meeting video so that we could observe what had happened. The videos confirm that, indeed, the other three councillors, plus CEC Councillor Julie Smith, and the clerk were in possession of these private emails. Councillor John Smith threatened to publish them. We even found that these emails had been passed to the MO and quite possibly an investigator, and were being used against us. We also found out they were passed to Chelk and Jackie Weaver. This caused us great distress, and AB launched an immediate investigation. So you get a proper investigator on the job. Hey, yeah? Me. A professional one. At this point, it is important to note that these series of emails also contained emails between us and our legal representatives. This makes those emails and communications privileged. That privilege has been harmed, and it has not been done by us or our legal representatives. Our privacy has been completely breached again. We also viewed it that private electronic communications are being illegally monitored and seized. The first question that had to be asked was, did one of us mistakenly send an email or chain of emails to the wrong email address? The only way to get this answer was to reinstruct our solicitor, which ensured that we suffered further financial loss. Councillor John Smith and the clerk initially ignored the letters sent by our solicitor. A final letter containing a very formal and last warning was sent to Councillor John Smith. In council, he stated that the emails were on the HPC servers having been sent to b.berkel@handforth.org.uk. He refused to respond to the letter, but ingress did cease and he stopped reading out the emails in council. This was largely because of the second part of the investigation, which ran side by side of part 1. We had instructed an IT forensic expert to inspect our private email addresses to see if they had been compromised or hacked. The answer was that those of BT and AB had been so compromised or hacked between February 2021 and April 2021. This covered the exact time period when the chain of emails that Councillor John Smith had in his possession had been sent. The forensic IT expert found that at no time did we send the emails to b.berkel@handforth.org.uk, as we did not know of the existence of this email address. How can we send an email to an email address that we did not know existed? The answer is that we simply cannot. We were advised and shown that the original emails were not sent to this address but were sent to b.berkel@btinternet.com. The email address was, in fact, changed by the hacker. These emails, therefore, constituted stolen goods pursuant to Section 22 of the Theft Act 1968. This was also an unlawful invasion of our privacy, which directly violated our right to privacy and respect and family life that is afforded us by Article 8 of the Human Rights Act 1998. Furthermore, the fact that they were provably used against us during the course of the investigation also ensured we did not get a fair hearing in accordance with Article 6 Human Rights Act 1998. Contact has been made with the MO and Mr Kitson of Bevan Britain with respect to this occurrence, but no response has been forthcoming and there has been no cooperation from either party. To find that someone had done that generated terrific shock, distress and upset in all three of us. It also caused great concern to our families and friends. AB was subject to nasty and vile hate messages via his Facebook Messenger. This greatly upset him and caused him to suffer a severe setback in his recovery from the illness, which forced him to sadly resign as a councillor. We now reach the conclusion. The conclusions are noted thus. 1. In relation to issue 1, the assessment found that there could be a case of forgery here, as the document that came into possession of Councillor Sampson was clearly altered without consent and with a name to deceive and use it as evidence. This counts as an act of fraud occasioned by forgery and is thus evidence obtained by or through trickery and would make this evidence legally inadmissible. The assessment held that Councillor Sampson made no request to BT, AB or BB for the document, and given the complete breakdown and non-existence of amiable relations between Councillor Sampson and BT, AB and BB, that she would not have even been supplied with a copy upon request. Her request would have failed, as there was also inherent lack of trust in her ability to keep documents such as this confidential and secure. Therefore, the assessment found that, on the balance of probabilities, she acquired it illegally and then used it as evidence against BT, AB and BB. 2. The assessment had to ask and attempt to answer the question as to how she illegally acquired it. There were 2 possibilities established. 1. She obtained it via fraud in that someone possibly known to her gained illegal access to personal email addresses. Or 2. That there has been a miscalculation, huge in magnitude, in the MO's office in that someone knowingly but negligently, recklessly and without the consent of BT, AB and BB supplied Councillor Sampson with a copy. Consent from BT, AB and BB would have been needed as it was confidential to them, and they had so shared it with CEC in confidence, which required consent for it to be passed to a third party. This needs to be thoroughly examined to ensure it did not happen. This is an ongoing investigation, and at this moment in time, Cheshire is still refusing to cooperate with our questions. 3. The assessment found that, on the balance of probabilities, that this piece of evidence, that being the front page of the legal advice, was illegally acquired and therefore was inadmissible as evidence. 4. Issues 2 and 3 were addressed together by the assessment. The assessment noted that, regarding these two issues, that evidence which has arisen via breach of other statutory instrument has been considered. Any evidence which has either been obtained by deception or has come about as a direct result of breach of law or by breach of human rights is also legally inadmissible and must be excluded. It was also noted that BT, AB and BB took advice from counsel regarding the cut and splice videos of the 10th of December 2020, and it has been concluded that the recording of the meeting, which was provably not a public meeting, was done in breach of Article 13 GDPR, and that none of the attendees were informed that the meeting was being recorded and would be published. This was also a breach of Article 5.1 and 5.2 GDPR, in that the personal data therein was not handled transparently and therefore is a prima facie data protection breach. Anyone coming into possession of said personal data has a duty of care to ascertain that it has been legally acquired. This did not happen. There was a woeful and alarming failure to ensure that this had been done. It is fundamentally believed that no proper duty of care was discharged by the MO or the investigator in this respect. The ICO has delivered a judgment in this instance, and they have confirmed that the action of the recording of the said video, the planning to do that and its dissemination was an illegal and unlawful misuse of personal data. They confirmed that the advice from counsel was legally correct and advised that the video containing personal data should not have been processed as evidence. Again, this is a serious breach of law, rendering CEC's investigation legally invalid. Paragraph 5. The assessment found and held that both these videos were pieces of evidence which had been legally acquired and were therefore prima facie inadmissible as evidence and should not ever have been used as such. The videos constituted tainted evidence as they were obtained and came about by illegal means. These should have been categorised as fruit of the poisonous tree and noted as being inadmissible and therefore unusable. 6. Issues 4 and 5 were addressed together by the assessment and gave rise to much serious cause for concern. It is clear from the known facts and evidence that an extremely devious, deceitful and malicious attack had been perpetrated against BT, AB and BB. It was clear that emails that were of a sensitive and privileged nature were illegally required. It must be remembered that REPA 2000 and IPA 2016 prohibit the monitoring of communications, whether by post, telephone or internet usage. It is abundantly apparent that somebody was illegally monitoring said private and privileged communications via the internet. 7. The assessment also accepted that hacking is a form of fraud, and that goods that become materialistic, i.e. real and physical, as a result of said fraud are stolen goods by definition provided by Section 22, Theft Act 1968. 8. There have been written requests to the MO and Mr Kitson dated 26 January 2022, 18 July 2022, 31 March 2023 and 25 April 2023, which have now been seen by the investigation. Of concern, there have been no responses forthcoming, and this extremely serious matter has been ignored and left unresolved. It is fair in these circumstances for BT, AB and BB to more automatically infer that by the silent response to these fair and reasonable inquiries that the emails in question were unfairly used as an extension of the investigation against them. This in turn meant that they were not afforded a fair hearing in accordance with their Article 6 Human Rights Act right. Paragraph 9. The fact that the personal email addresses of BT and AB were compromised and that these emails misappropriated was a serious violation of the rights conferred by Article 8 Human Rights Act 1998. This violation did materially affect BT, AB and BB as these emails were private. They were between them and in some cases between themselves and their legal representative. Their right to privacy and respect has been totally breached by this occurrence. 10. There can be no defence afforded to CEC's MO regards to these two issues. He was openly and politely advised what had happened. He was alerted but showed an incomprehensible level of ignorance. This cannot be ignored, as in taking possession of emails he has committed a criminal offence and in so doing has brought CEC into disrepute. The same is said of Mr. Kitson. He has not helped his firm at all. His firm did choose to ignore it too, and they have no defence at all. 11. In relation to issues 4 and 5, the assessment found that there was an unqualified and running use of evidence that had been acquired by way of fraud. This means that it was legally inadmissible and should not have been used as evidence, let alone for the purposes of maliciously extending the investigation against BT, AB and BB. The assessment found, and this is the final paragraph, that on the balance of probabilities, all 5 counts under this heading were approved. Evidence that was acquired illegally had been taken, accepted and used as evidence. This completely invalidates investigations and nullifies all findings. It is recommended that a new investigation be instigated with an investigator who knows the rules of evidence. And this has been done. Thanks for tuning in. Thanks for being there. We'll be back with grounds 11 and 12 shortly.